Well, we're focusing on those conflicting court judgments as has been described in several dailies. Well, Daniel Bwala joins us today to help make sense of this morning, and thank you for joining us today. Well, the thing about all of this is, first and foremost, there's a verdict by Justice A.M. Liman of the Federal High Court sitting in Port Harcourt. It ordered the Independent National Electoral Commission, INEC, to recognize the McCarthy-led committee of the PDP and grant leave to the party to issue as concurrent, originating summons and other processes in the suits. It goes on saying basically that committee is recognized, should be recognized by law. But then in another breath, you had another court, this time a concurrent one, of concurrent jurisdiction in Lagos, sacking that same committee. And many just wonder, they don't understand how two courts in the country on the same matter give conflicting judgments. How do you interpret this, and how should this be obeyed?
Well, thank you for having me. It is very sad that we have this kind of conflicting orders by the Court of Coordinate Jurisdiction. But it is not far-fetched, and the solution is just simple. Section 287, sub 3 of the Constitution states that the Federal High Court, High Courts, and any other court's decision is enforceable throughout the Federation by persons and authorities, and especially courts that are subordinate to the court that makes that order. Now, the doctrine of first in time will have to be played in the circumstance. Which of the Federal High Court's decision came first? If it was the decision of the Federal High Court in Port Harcourt, then the order of the court in Lagos is inconsequential and mere academic because of the provision of Section 287 sub 3, because that order of the High Court, of the Federal High Court in Port Harcourt, was delivered at a time when there was no subsisting order by a court of coordinate jurisdiction, so it's valid and constitutional. But then the subsequent order of the court in Lagos now becomes unconstitutional because that order can only be obeyed by a court that is subordinate to it, and in which case the court in Port Harcourt is not subordinate in any ways to it. And this is one of the reasons why the public confidence in the judiciary is waning on a daily basis, and people are raising so many issues of corruption and all of that.
But then many looking at this wonder, rather than expose ourselves or be faced with this kind of situation, is there no way, because I think it's been talked about before in terms of judicial reforms, isn't there a way that courts can actually check and be sure that certain judgments have not been delivered before you then go ahead and deliver judgment on the same matter, and then perhaps, in the manner of speaking, ridiculing the judiciary?
The problem we have in Nigeria is that we have consistently refused, the judiciary either is incapacitated or underfunded or deliberately refused to employ these techniques of electronic case management system. In England, if a high court in London delivers a ruling or a judgment regarding a matter, the high court in Liverpool, for example, if a matter similar to it comes before it, before the court will deliver the judgment, the judge will have to look at a similar decision by a court of coordinate jurisdiction, in which case is the court in London, and look at the principle upon which the court arrived at that decision. And if it's going to be conflicting, either it will decline jurisdiction or toe on the path of the decision of the court in London. Now, if we have electronic case management system here, that it means that when the Federal High Court in Rivers State delivered that ruling, the Federal High Court in Lagos ought to have had access to that ruling. And if that kind of similar case appears before it, the court will simply decline jurisdiction or make it clear to the parties that there is a substituting order by a court of coordinate jurisdiction, and therefore will do nothing about that. But what we find in Nigeria is that some of the judges just ply on this euphoria of judicial activism. Otherwise, how else can you judge a situation like that? It is very, very sad, and it is gradually becoming worrisome in Nigeria. There should be a case management system where the court will speak with one voice. But the idea that a court will deliver a ruling, another court will deliver it when the facts are on all fours with each other. And have you not noticed in Nigeria, for example, over the years, that in our corpus juris, we have so many cases. We have land cases, we have probate cases, we have investment dispute cases, tax cases. We have settled laws on that, and you rarely find this kind of forum shopping by lawyers and politicians, people, because the decision, there is a well-settled decision on that. Why is it that it's only on political case matters that you find a similar issue going from the High Court right up to the Supreme Court over and over and over? And on a matter, for example, on an interlocutory application, you have more than 20 decisions of the Supreme Court on that. Keep coming and try to see if they can change the mind of the judge. So the reason why the public confidence is going down is because it's only on political cases that we find this kind of anomalies. In all other cases, once a decision is delivered, it is settled, people don't even waste their time to go on it. In England, if a judgment is delivered in a matter and you are going on appeal, you have to be sure that your appeal is appealable. If you go to the Court of Appeal and your interlocutory appeal or substantive appeal is meeting a well-settled law, in the first place, they may not even accept it for filing. And in case they do, because probably you come up with one other issues that is considered novel, if at the end of the matter, your appeal is seen as frivolous, that lawyer that takes the matter will be punished.
In all of this, I think you just hit it on the head, that this is only akin to politics when it comes to issues of having conflicting judgments. But going down the hill, how do we remedy the situation? Now you are also a teacher of law, and when lawyers come before politicians and politicians also approach these lawyers, what should they be saying to them in matters like this?
To be honest with you, I cannot exonerate the lawyers. The lawyers are the principal actors in all of this situation. Even this war against corruption of the president, which all of us support, lawyers are not helping matters. Politicians don't know how to file application. Politicians don't know the nitty-gritties of the law. Politicians and confidence, the client lawyer privilege communication is such that you cannot question the lawyer on the information given to him by the politician. It could be admission of facts, but then he has to defend him consistent with our law. It is the lawyers who go for forum shopping. Look at the cases in Nigeria. You come to this court with the same application, you don't get it. You go to another court for the same application, you don't get it. You try another court, the same application, you don't get it. Similar jurisdiction, challenging this tribunal, challenging this court. All of these things are frivolous. And the CJN has decried this kind of very unhealthy attitude of lawyers. I think that the Nigerian Bar Association should also look into it. Sadly enough, it is senior lawyers that are involved in all of this situation. There is a known fact that a lawyer cannot reject the brief that the client gives to him. But then we owe the duty, as provided by Rules 1 of the Rules of Professional Conduct, to uphold the rule of law, to foster the cause of justice, and not to be engaged in any act that is unbecoming of a legal practitioner. You have a duty to advise your client on the course of action that is convenient for him and good for the polity. The war against corruption is suffering now because of the attitude of lawyers.
But at the moment, when, yes, you've said that the principle has got to apply whichever one comes first, especially when it's got to do with courts of coordinate jurisdiction. What do you do or say to people who think that, well, that may be the case, but you have a court judgment that is lying fallow and not being obeyed?
Right. An order of a court is valid and subsisting and enforceable unless it is vacated or overturned by an appellate court, either vacated by the same court on a facts brought before the court, which the court is convinced that the previous decision was arrived at having been misled by the court, or by an appellate court having reviewed the decision of the lower court and the appellate court decides that the decision was reached by incurium. However, the violation of the court order depends on whether that order can be construed in law as valid and constitutional. Like I told you, the decision of the court in Rivers State is valid. The ruling of the court in Lagos is not valid. You have to look at section 287 sub 3 of the Constitution. If you read it, then it is clear that that order of the court in Lagos can only be valid if it variates an order of a court that is inferior to it. In this case, the decision or the ruling of the court in Rivers State, that court is a court of coordinate jurisdiction. And by the rules of our the judicial precedent, we have seen that in election petition throughout Nigeria, where the Court of Appeal or a tribunal will give a decision, another tribunal will go, another way, Court of Appeal will give on this side, another Court of Appeal will go different direction. There are two things to it. First, a court, the judge or the tribunal judges might honestly, having reviewed the evidence before them, arrive at a judgment that the appellate court may find that the judgment was given in error. It does not necessarily mean they collected a bribe or they were influenced. That's one scenario. But then we have other scenario where when you read the judgment, you cannot but arrive at the conclusion that that judgment was obtained in a manner that cannot be explained in the terms that somebody will understand. And then the worrisome, the worrying thing is that why is it that only in political cases, some of these politicians, you need to hear how much they pay to get this judgment, to get these rulings, because you do not have the evidence, you keep speculating. And if a judge gives a judgment or an order that is obtained on corruption basis, there is a remedy in law. There is a way you can get redress from the conduct of that judge if you can show that that judge collected a bribe. There is no doubt that there is corruption in the judiciary. But you cannot use that to generalize. There are good judges who deliver good judgments that are overturned on appeal, and there are judges, let me tell you this, a bad judge, a corrupt judge is more dangerous than a madman on rampage with a dagger, because the madman on rampage with a dagger can be curtailed by the community of help, but the judge's judgment destroys the very moral value of the society. And over time, rule of law will no longer be an issue. That is what we find in Nigeria. Is there rule of law? There is impunity and rascality. Look at the issue of PDP. So factionalized, it is like you're saying you're unbundling PDP. That is, it's not just PDP. This imposition and rascality which you are seeing is also applicable to all other parties, including the APC. The only difference is that now they are in power. Some of the people in APC are members of PDP who were principal actors in imposition, but now are in APC. But because they are under the leadership of a man that is considered as a man of integrity, they decide to keep quiet about this whole thing. So institutional reform is necessary, but then a radical step to make sure that the judiciary is somehow checked to avoid this corruption is very, very important for us in this country.
So, in summary, from your submission, if the police were to look at this matter, what you're saying is, if you could predicate your argument on Section 2873, it means whether or not the court decision in Lagos was delivered per incurium, it's simply not enforceable. The one of Port Harcourt is the right one.
Correct. The decision of the court in Port Harcourt is correct because it was delivered not against any subsisting decision of the court of coordinate jurisdiction, and Section 285 sub 3 support that. But the ruling of the court in Lagos is invalid and unconstitutional because it cannot vary or set aside the decision by a court of coordinate jurisdiction having regard to the provision of Section 287 sub 3. Only an inferior court that the decision or ruling of the court in Lagos can have a binding force over.
All right, Daniel Bwala, also a member of Lincoln's Inn in London. Thank you for talking to us today. Well, there you go. That's a wrap on the show, and we'll draw the curtains here today on the program. Well, thank you for watching and for sending your comments as well. We'll see you tomorrow. I'm Chamberlain Uso.
I'm Nail Type. We have a good day.
Many thanks. I'm Sulaiman Alede.